Judicial activism is a fancy phrase for a very plain thing. When the law says A and the judge wants it to mean Z, he interprets it as meaning Z. Deep thinkers may call that judicial activism. Back where I come from, we call it lying. Judges don't just twist and stretch the law for fun. Usually they do it to promote some article of faith in the liberal creed. That's what wins them the support of the media and academia. Attempts to justify judicial activism are very complicated and very clever, but they boil down to the kind of excuses any parent of a small child should be used to hearing. With small children and judicial activists alike, the first excuse is that they didn't know you didn't want them to do what they did. Judicial activists and their supporters claim that the original intentions of those who wrote the Constitution are unclear. But it so happens that the people who wrote the Constitution of the United States were very straightforward writers, much clearer than most law professors. As with some children, however, the problem is not that the judges don't know what the rules are, but that they don't want to follow them. The ploy is to say that no one knows exactly what is meant by constitutional phrases like due process or cruel and unusual punishment. If you want to play that game, no one knows exactly how far it is from the Washington Monument to the Tower of London. When you get the distance in miles, you can say that's not exact because you want it in inches. And when you get it in inches, you can say that's not exact because it's not accurate to a millimeter. There's no limit. But if you use the fact that no one knows exactly how far apart they are to argue as if they are only about 3 blocks apart, or over 1,000,000 miles apart, then you are lying, or engaging in judicial activism, as deep thinkers say. This is the game that Supreme Court Justice William Brennan played when he said, "We cannot know exactly what the framers thought cruel and unusual punishments were," as he reversed a death penalty decision as unconstitutional. What the framers of the Constitution clearly did not mean was the death penalty. They explicitly mentioned the death penalty in other parts of that document. All the states that ratified the Constitution had death penalty laws. The first Congress that ratified the Constitution also passed federal death penalty laws afterwards. Pious talk about how hard it is to know exactly what the writers of laws meant is almost invariably used to justify things that they clearly did not mean. Judicial activists like Brennan play the same game with the phrase due process. This legal expression was already hundreds of years old when it was first written into the United States Constitution. For Supreme Court justices and law professors to pretend to wide-eyed innocence as to what it means at this late date is a little much. Of course, no one knows exactly what it means, but for centuries it never meant that criminals had to be turned loose if the cops didn't advise them that they could stonewall. You don't need to know exactly how tall the Washington Monument is to know that it's taller than you are, and that any statement to the contrary is false. When the Innocent Act fails, judicial activists fall back on the fact that change has occurred since the law was passed. Change is a magic word used to justify decisions that have nothing whatsoever to do with change. The most famous or notorious Supreme Court decisions of the past generation have had no relationship to any of the many changes that have occurred since the Constitution was written. Death penalties are still death penalties. Abortion is still abortion. Segregation is still segregation. Libel is still libel. And arresting a criminal is still arresting a criminal. And lying is still lying.